Good evening everyone! Let me continue the report of Group 5 regarding the effects when resolutory condition is fulfilled. Ito yung mga epekto kapag natupad ang kalagayan ng resolutory. So, what is resolutory condition muna? Dito naman nangyayari yung obligation na ginagawa pero once na ma-fulfill na yung obligation, mawawala na yung obligation. So, number 3 na tayo. The fruits or the interest thereon should also be returned after deducting the expenses made for their production, gathering, and preservation according to the Article 443. For example, bumili si Aling Mamita sa kanyang kumare ni si Maring Mars ng mga gulay. Therefore, obligasyon ni Aling Mamita o responsibilidad niya na bayaran yung ginastos o binili niya na gulay sa kumare niyang si Kumaring Mars. Next, number 4, Article 1189. We apply to whoever has the duty to return in case of the loss, deterioration, or improvement of the thing. According to the Article 1189, when the condition have been imposed with the intention of suspending the efficacy of an obligations to give, the following rules shall be observed in case of the improvement, loss, or deteriorations of the thing during the pendency of the condition. First, in case of loss of the thing, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. For example, Mr. Gonzales obliged himself to give Bonifacio a determinate car if he passes the CPA exam in May the current year. If during the pendency of the condition, the car was lost through fortuitous event without the fault of Mr. Gonzales, the obligations to deliver the car is extinguished even if the condition is fulfilled later. So, kapag nakapasa si Bonifacio sa CPA exam, obligasyon ni Mr. Gonzales na tuparin yung ipinangako niya kay Bonifacio. Pero kapag hindi nakapasa ng CPA exam si Bonifacio, maaring mawala yung responsibilidad niya or tungkulin na ipinangako niya kay Bonifacio. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is to understood that the thing is lost when it perishes or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. For example, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages. If in the example above, the specific car was lost through the fault of Mr. Gonzales, he shall be liable for the damages upon the fulfillment of the condition. Second, when the thing deteriorates during the pendency of the condition without the fault of the debtor, the impairment is to be borne by the creditor. For example, Arvin obliged himself to give Ian a determinate Toyota car if Ian passes the October CPA exam. During the pendency of the condition, the car was partially damaged by flood without the fault on the part of Arvin. If the condition is fulfilled, Ian will bear the impairment. Obligasyon o responsibilidad ni Arvin na bigyan niya si Ian ng Toyota car if makakapasa siya ng CPA exam. Kapag may nangyari sa sasakyan or nagkaroon ng damage, maaaring si Ian ang managot at hindi na ito kasalanan ni Arvin. Next, if the thing deteriorates during the pendency of the condition through the fault of the debtor, the creditor may choose, after the fulfillment of the condition, between the rescissions of the obligation or its fulfillment with indemnity for damages in either case. Third is when the thing improves. So, kailan nga ba na-improve ang isang bagay? If the thing improved during the pendency of the condition by its nature or by time, the improvement shall be inured to the benefit of the creditor. The reason for this is to compensate the creditor who would suffer in case instead of improvement, there would be deterioration without the fault of the debtor. If the thing is improved at the expense of the debtor, he have no other right than the granted to the usufructuary. By usufructuary, it means the right to enjoy the property of other, which includes the right to enjoy and use the fruits of the property. That's why the court are given power to determine the retroactivity of the fulfillment of resolutory condition. For example, A gave B a parcel of land on condition that B will pass the CPA exam on May this year. B did not pass the CPA exam, the obligation is extinguished, and therefore, it is as if there was never an obligate at all. B will therefore have to return both the land and fruits he had received there from the moment A has given him the land. 1, 2, 3, 4, 5. The effects when resolutory condition is fulfilled because the obligation is extinguished and considered to have had no effect. The parties should restore to each other what they have received. Ngayon, magpo-proceed na tayo sa Article 1191. The power to rescind obligations is implied in reciprocal ones in case one of the obligors should not comply with what is incumbent upon him. Dito naman sa Article 1191, may mga kapangyarihan na bawiin o ipawalang bisa ang isang kasunduan na ipinahayag sa palitan ng obligasyon kung ang isa sa mga pananagutan ay hindi tumupad sa mga nararapat niyang gawin. The injured party may choose between the fulfillment and the rescission of the obligation, with payment of damages in either case. He may also seek rescission even after he has chosen fulfillment if the latter should become impossible. The court shall decree the rescission claimed unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of the third person who have acquired the thing in accordance with Articles 1385 and 1388 and the mortgage law. Dito naman ipinapayag ang nasugatang partido ay maaaring pumili sa pagsasakatuparan o ang pagbawi ng obligasyon na may parehas na katapat na kabayaran para sa danyos. Maaari ring piliin ng ikalawa kung ang pagsasakatuparan ng obligasyon ay imposible. Kung ang hukuman ang mag-uutos ng pagpapawalang bisa na hinihingi maliban kung may katarungang dahilan para pahayagan ang pagtatakda ng tiyak na panahon. Let's proceed to the next topic, the right to rescind. What is the right to rescind? It is the power to rescind or right to cancel or resolve the contract or reciprocal obligation in case of non-fulfillment on the part of one. Right to rescind it is mean the right to cancel or to resolve in case of reciprocal obligation in case of non-fulfillment on the part of one. For example, in a contract of sale, the buyer can rescind if the seller does not deliver or the seller can rescind if the buyer does not pay. The power to rescind is given to the injured party and the injured party has the following alternative remedies. These are the demand fulfillment of the obligation plus the damages, and the second is the demand of rescission of the obligation plus the damages. Next is reciprocal obligation. It refers only to reciprocal obligation, that is to obligation where two parties are reciprocally obliged to do or give something. For example, contract of sale. It is not enough that both parties are intended to each other. The cost must be identical and the obligation should arise simultaneously. So, this obligation where two parties are reciprocally obliged to do or give something like a contract of sale. Ito yung example natin kanina, di ba? Yung contract of sale. So, that it is not enough that both parties are intended to each other because the cost must be identical and the obligation should arise simultaneously. Parenthetically, in reciprocal contract or transactions, the obligation or the promises of each party is the cost or consideration for the obligations or promises of the other. These are the characteristics of the right to rescind or resolve under the Article 1191. First is it exists only in reciprocal obligation. So, however, if the obligation is reciprocal but with a period, neither party can demand performance or be considered in default before the expirations of the period. The second one is, it can be demanded only in the plaintiff is ready, willing and able to comply with his own obligation, and the other is not. So, otherwise, if neither is ready, neither can resolve or hindi mareresolba. Moreover, the guilty party cannot rescind, and he who comes to equity must come with clean hands. Number 3 is the right to rescind is not absolute. A. Yung tribal causes or slight branches will not cause rescissions. It must be based on a serious or substantial breach of an obligation as to defeat the object of the parties in making the agreement. A mere casual breach does not justify rescissions of the contract. For example, if time is not of the essence in the performance of his obligations, it is not sufficient ground for the resolutions of the agreement. So that if there be a just cause for mixing the period within which the debtor can comply, the court will not decree rescission according to the Article 1191. If the property is in the hands of an innocent third party who has lawful possessions of the same. Number 4, the right to rescind in certain cases. Ito yung karapatang magalis ng ilang mga kaso. A. Judicial approval is needed when there has already been delivery of the object unless there is a voluntary returning. Ibig sabihin na to, kailangan na pag-aproban ng panghukuman kung mayroong naihatid na ang mga bagay. Maliban doon ay isang kusang loob na magbabalik or voluntary. Sa letter B, judicial approval is not needed when there has been no delivery yet, or in case there has been delivery, the contract stipulates that either party can rescind the same or take possessions of the property upon non-fulfillment by the other property. Dito naman, hindi na kailangan ng pag-aproban ng hukuman kung mayroon or wala pang pagpapahatid, or kung sakaling mayroong paghahatid na or tinadhana ng kontrata ng limang partido ay maaari ng tagalin ng pareho o mag-aari ng pag-aari sa hindi natupad ng ibang pagdiriwang. Number 5, the right to rescind is implied or presumed to exist and therefore need to be expressly stipulated. Ito yung karapatan na pwedeng magtanggal para may pawiwatig or maipalagay na mayroon, at sa makatuwid, hindi na kailangang pwedeng linawin yung nakasaad. And number 6, the right to rescind may be waived expressly or impliedly. Ito yung karapatan na pwede kang mag-alis or maaring talikdan. Pwedeng dapat malinaw or nagpapahiwatig ito ng maayos. Choice by the injured party. The injured party may choose between fulfillment, specific performance plus damages, or rescission plus the damages. Maaring pumili ang nasugatang partido sa pagitan ng pagtupad or tiyak na pagganap kasama ang mga pinsala or yung pagsagip plus pinsala. The right is alternative. The right is not conjunctive. That is, the plaintiff cannot ask for both remedies. However, in the interest of justice, partial rescissions and partial fulfillment may be allowed. The injured party who has elected fulfillment may, if fulfillment be impossible, still ask for rescissions or provided rescissions is proper. If an action is brought for a specific performance, the damages sought must be as in the same action. Otherwise, the damages are deemed waived. Based from my understanding or opinion, ang kanan ay kahalili, ang karapatan ay hindi magkaugnay. Iyon ay nagsasakdal ay hindi maaaring humiling ng parehong mga remedyo. Gayunpaman, sa interes ng hustisya, bahagyang pagliligtas at bahagyang katuparan ay maaaring payagan. Ang nasugatan na partido na naghahalal ng katuparan ay maaaring, kung posible ang katuparan or magtanong pa rin para sa pagliligtas. Or ibigay ang mga pagliligtas ng tama at isaayos. Kung ang isang aksyon ay sinasagawa para sa tiyak na pagganap, ang mga hinahangad na dim ay dapat pa rin tanungin sa parehong pagkilos. Kung hindi man, ang pinsala ay tinuturing na kinawalan or waived. Now, I will proceed na po sa Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished and each shall bear his own damages. According to the Article 1192, kung sakaling ang parehong partido ay nakagawa ng isang paglabag sa obligasyon, ang pananagutan ng unang infratractor ay dapat pantay na kinalma ng mga korte. Kung hindi matukoy kung alin sa mga partido ang unang lumabag sa kontrata, ang parehong maipapalagay or yung deem extinguish at ang bawat isa ay magdadala sa kanyang sariling mga pinsala. Rule if both parties have committed a breach. Section 2, Obligations with the period. Article 1193, obligation for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Ito naman po yung panuntunan kung ang parehong partido ay nakagawa ng isang paglabag. Ayon sa Artikulo 1193, ang mga obligasyong para sa kung kaninong pagtupad sa isang araw na natukoy ay naayos na, ay hihilingin lamang pagdating ng araw na iyon. Obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional and it shall be regulated by the rules of the preceding section. Ang sabi po dito, ang obligasyon na may isang resolutory na panahon ay magkakabisa ng sabay-sabay. Ngunit natatapos ito pagdating ng araw na tiyak. Ang isang araw na tiyak ay nauunawaan ng iyon ay dapat nang dumating. Kahit na hindi ito maaaring malaman kung kailan. Kung ang kawalan ng katiyakan ay binubuo sa kung darating ang araw o hindi, ang obligasyon ay may kondisyon at ito ay dapat na makontrol din natin ang mga patakaran or rules ng mga naunang section. Okay, dumako naman po tayo ngayon sa period. A period is a certain length of time which determine the effectivity of the extinguishment of obligation. So, what is period? Period, it is defined. A period is a future and certain length of time which determines the effectivity of the extinguish of obligations. These obligations with the period is one whose consequences are subject in one way or another to the expiration of said period or term. A day is understood to be that which must necessarily come, although it may not be known when. Hindi natin alam kung kailan malalaman. Lagi lang po nating tatandaan, ang period ay isang hinaharap at tiyak na haba ng oras na tumutukoy sa pagiging epektibo or sa napapatay na obligations. Always remember, the period is a length of time which determine the effectivity or the extinguishment of obligation. Ayun lang po. Again, I am Recipe Cañete, a reporter of Group 5 from BSA 1B. Thank you!